Hello again, everybody. My name is Jason Hanford. I'm an attorney at the Chartwell Law offices. I'm a Pennsylvania workers' compensation attorney, and we're filming today what is the second in our series of videos interviewing different Chartwell attorneys about different emerging legal issues in our practice. Last week, I had an interview with Brittany Atkinson from our New Jersey office about COVID-19 claims in New Jersey. I encourage you to go back and watch that video if you haven't already, and if you did, thanks for coming back. As before, if you have any questions, feel free to reach out to us by email or phone, or leave comments on the social media platforms where we post the video. Leave your encouraging and nice comments. If you have mean comments, I guess send a private email so that everybody doesn't see the funny jokes you have about us. I'm joined today by one of my favorite people and one of the better attorneys I've ever met, Lee Fiederer, my partner from our Philadelphia office. Lee, can you say hi to everybody?
Hello, everyone. Good to talk to you about COVID-19 and PA workers' compensation claims. I hope everyone is staying healthy and being careful.
Lee, I think we're the first attorneys to reach out to our clients about COVID-19 claims. Would you agree with that?
Well, I'm pretty sure our clients have been inundated with different emails or invites to talk about COVID-19, so we'll try and keep ours brief but informative.
Yeah, and that's why we're doing the video series. It's a little bit of a different vehicle, a different way to get some of the information, and it's a little more free flowing. So we hope you tune in, and we also hope that everybody's doing well. We hope that all our clients and their families and the friends of the firm, everybody's safe and staying healthy. We're persevering. We're going to get through this together. So maybe a couple more weeks and things will start inching back towards normal. Before things get back to normally, though, we want to talk about Pennsylvania employers. That's what you and I do, Pennsylvania workers' compensation law, and what a Pennsylvania employer does when an employee comes to them or phones them and tells them, "Hey, look, I've been diagnosed with coronavirus, with COVID-19. What's the initial response that you think an employer should have?" What I really want to talk about is the conversation with the employee. So, what's your first response going to be as the employer?
Right. So I think that our employers and our adjuster clients need to do many of the same things they would do on a typical claim, but also some different things. So our employers and insurance carrier clients need to find out more from the claimant about why they think the exposure to COVID-19 happened at work in the first place. As we know, every workers' compensation claim involves an element of causation. What was the cause of the condition? In some environments, it may become very clear that the cause of the injury may well have been related to work. A healthcare environment where patients with COVID-19 are being treated may clearly, in the minds of many of our judges, lead one to conclude that the claimant who now has COVID-19 as well was exposed at work. Less clear, however, are other work environments. What about the person who works in retail, stocking shelves, with limited customer interaction, and with no known, for example, coworkers with the condition? Is that a claim where there's a causal relationship between what happened at work and COVID-19? Not so clear. So I think that the first avenue we want to explore with a claimant who comes to us saying that they believe they had a COVID-19 work exposure is, why did they think that?
I don't want to make you go through individual questions for the employee, but when we're talking about first off the workplace and asking them about any workplace exposure, what kind of general topics are you going to cover with the employee?
Right. So let's just, first of all, we want to know whether the person actually has reached the diagnosis or is just symptomatic, whether they have a confirmed diagnosis, whether they're treating. But we want to know a lot of things about how long they've had the condition, or they think that they've had the condition, why they think that they got it at work, whether they're on the road to recovery already. I can't get into every question, Jason, because we'd be here for a couple hours, and I promise to be brief. Anyone who wants to check in with us afterwards surely should do so, because we do have a developed list of questions to ask claimants about why they think that their exposure happened in the workplace. But that causation angle is going to always be key.
And Lee, I know that you're going to ask them about issues outside of the workplace as well, and I want to get to that next. Before I do, I did want to note for people watching the video, And depending on when you're watching the video, I don't know that many people will be going back a year from now to watch this production, but God bless if you are. And if you are, it's very possible that there's new legislation put forth in Pennsylvania, as there has been, I think, in a few other states already, regarding a presumption in the act about certain employees are entitled to the presumption that if they have COVID-19, it came from the workplace. That's not the world we're living in today. So we're not talking about that today. We're talking about the act as it is today, which is April 7th, 2020. So if the law changes next week, then we'll come back on and we'll do another video. But we wanted to note that we're not trying to ignore that potential elephant in the room. But our clients out there, our employers, our claims adjusters have to deal with the law as it is today. So I wanted to provide that sort of proviso. And then Lee, if you wanted to get into beyond just the workplace, are you going to ask them about their exposures, potential exposures outside of the workplace? And if so, why are you going to ask those kind of questions?
Right. So Jason, just to wrap up your last point, even if the legislature amends the act to make a presumption for certain types of workers, it's typically a rebuttable presumption. It might be a hard presumption to successfully rebut, but there will still be probably an avenue to challenge that presumption. But let's talk about home environment. Why does the claimant think that it was more likely they were exposed at work than somewhere outside of work, such as their home? Do they have a family member that they're treating for the condition? Have they been engaged in large social gatherings in the last couple of weeks? Do they know of someone else outside their family who has the condition, and have they been with that person? Again, we have a long list of questions, and I'm happy to develop it with any individual client on a tailored basis. This is general advice. This is not tailored or suited for your individual case or your individual type of work or place of business. But you always want to be exploring other angles about why it might not be a workers' compensation case in the first place.
And Lee, I think that dovetails into another issue that we had discussed offline. It's certainly from a claims handling standpoint, it's good to narrow down if there's an outside of the workplace exposure. We all know why for future claims handling. But I think it's also a potential issue for the employer in the workplace, as it were. So if you have an employee that's diagnosed with COVID-19, they're not going to be into work, we assume, for a couple of weeks. But if you really believe as the employer that they were exposed in the workplace, then you're probably going to react differently than if they were potentially exposed at home. Do you think that the employers, and it's an employment law question, but it's also a workers' compensation question, do you think employers need to be wary about their other employees when somebody goes out with COVID-19?
Yeah, so clearly if someone at work has COVID-19, regardless of where they acquired the condition or the disease, we have to have an immediate concern about whether coworkers have contracted that person. Has there been a meeting with the person who has the condition and other coworkers in a close environment before we started social distancing, for example? Has the person who has COVID-19, been walking around the office or taking a car ride with a coworker to a meeting before we engage social distancing? So yeah, we need to really be careful about making sure, first of all, as part of our investigation with the claimant, what other contact did they have with co-employees? And then again, this is kind of a big, broad question beyond the scope of what we're talking about, but within an employment law context, as permissible, getting the word out to people who may have also been exposed in the workplace from the infected person. It's probably bigger than we can discuss in a video conference, but it's a workers' compensation question wrapped up into a bigger employment law question.
And obviously there's going to be more things you're going to talk about with the employee. Of course, you're going to make sure that their health is secure and that they have everything that they need. You had mentioned before we got on the video about talking about other streams of benefits, other options available for the employee. What would that conversation be, and why would you be having that conversation?
So Jason, I've identified 5 alternative forms of benefits that an unfortunate person who has COVID-19 might opt for instead of workers' compensation, and which are probably better for the claimant in many regards. So let's go through them. First of all, there is the Emergency Paid Sick Leave Act, which the federal government just passed. So as we know, when it comes to COVID-19 patients, I'll try and put this gently, but people either tend to be asymptomatic or recover within a couple of weeks, or not do so well at all. Or I'll just leave it at that. If a person's going to be asymptomatic or recover within a couple of weeks, they are probably better off just simply opting for what's called the Emergency Paid Sick Leave Act. People are calling it e-sick. First of all, it provides them 2 weeks paid sick time, which might be enough to allow them to reach full recovery. So except for the very high wage earners in the workers' compensation system, who are always at a loss when it comes to receiving benefits compared to their pre-injury wages, except for those high wage earners, someone might do better under e-sick, and they don't have to litigate their claim. They don't have to go through the process of fighting and slugging out whether or not their injury was work-related in the first place. This e-sick legislation is pretty favorable to claimants. If you're unable to work, or even if you're symptomatic and seeking a diagnosis, in other words, you're waiting around to get that test that doesn't seem to be available readily to a lot of people, but you're symptomatic, you can opt for e-sick benefits. And if you're unfortunately stuck at home caring for someone who has COVID-19, you can also opt for e-sick benefits. So there's a dual benefit to e-sick benefits. Not only is it easier for the claimant to access and quicker than workers' compensation, there may be up to a 100% tax credit for an employer who funnels a claimant towards this benefit. So it's almost a no-lose proposition for both the employer and the claimant.
Lee, let me just jump in there for a second, both because I had a question and because your video's freaking out a little bit. I'll let you catch up with me, but I think the fast nature of receipt of the benefits probably would mean a lot to a lot of employees out there, because if it's a contested comp claim, you and I both know that it's going to be a long time, even if the claim is found compensable, until that claimant is paid for that period of time. Would you recommend to your employers, and I haven't looked closely at the new legislation, there might be some notification requirements in and of itself in the legislation. Would you recommend to your employers pushing that information out to the employee base, even ones who aren't reporting any sort of symptoms or issues, so that they're aware that, you know, if something pops up, if you're exposed to somebody at home and you start to feel symptomatic, there's these other streams of benefits out there? Would you put that out there proactively?
Yeah, so it's the first time I've been faced with the specific question that you're asking, but it seems like it's a good idea because it's a no-lose proposition for both the claimant and the employer, because the employer gets the benefit of this huge tax credit associated with paying the benefits. So it seems like it's something that you might want to let your employees know. I'm aware of employers who have made this benefit available, or at least informed their employment base that it is available. And so, yeah, I think it's a good idea to just let people know about it. I don't see any risk. I really don't.
Were there, I know you mentioned e-sick, were there other streams of benefits you wanted to talk about? We're running up on time, but I didn't want to cut you off.
So I'm just going to do these three and then we can try and conclude. FMLA Plus is now available. It's like the old FMLA with one huge exception. There's 2 weeks of unpaid leave, but then there's up to 10 weeks of paid leave for care of a dependent who has contracted the disease. So FMLA Plus is a benefit available. And let's talk about two other things. What about good old-fashioned state unemployment compensation benefits? Now, this might not be the right remedy, or this might not be the best fit for a workers' compensation claim, but sometimes people do avail themselves of unemployment compensation in lieu of or in addition to workers' comp. So we'd have to look at those more closely as to whether an unemployment compensation claim was viable, but again, it's a faster remedy. And lastly, what about disability policies? I don't know how a disability carrier is going to handle a claim that it only suspects might be related to employment. But again, just like we're going to suggest to some of our claimants that they might have contracted the condition outside of employment, the disability carrier may have to deal with that same issue as well, that it's impossible for them to show that the condition happened at work as opposed to outside of work. I think all four of these are potentially viable options. e-sick, FMLA Plus, possibly unemployment compensation, and disability, good old-fashioned disability insurance might be better options for a claimant and for an employer.
I did want to, and that's All very, I think, useful information for our clients, Lee. I wanted to point out that we did not coordinate our blue shirts.
I'm also doing my first mugshot here, so this is kind of cool.
And I did ask Lee if he has more lighting in his house, but he's a very frugal guy, so he couldn't bring up the lighting too much more. Lee,
Can't get candles anymore.
at the risk of going too long, but I think it's an interesting issue, and it was just kind of percolating in my mind while you were talking. I'll give you a bonus question, a final Jeopardy question, and I'll let our viewers know that I didn't prep Lee for this at all. So hopefully we'll trip him up and he'll look goofy. You were talking about exposures in the workplace and at home. You know, you're interviewing the employee, you're sort of separating out, okay, is this something that could happen in the workplace, or is this something that could happen at home? One thing that I talked about with Brittany last week, and one thing that's part of my reality, is I have a very close family member who works at a hospital in administration, and she works from home. She's working from home right now. What do you foresee, and how would it change and you probably know where I'm going with this, your queries, if you have an employee who's working from home and they feel that they are exposed at home because they have a relative, and would that be a compensable work injury in Pennsylvania?
You know, Jason, it's actually a bigger question than just the contracting of the COVID-19, because now we have so many people telecommuting and working from home. So Pennsylvania law has been pretty clear on this. If you're working at home and you sustain an injury during the course and scope of your employment while you're at home, it's a compensable Pennsylvania workers' compensation claim. And it almost doesn't matter, you know, how removed the claimant is from the actual work. So, for example, the personal comfort doctrine applies. If a person's got a home office in their basement and they want to go upstairs to where the fridge is to get some juice or water or coffee or something, and they trip on the stairs. This is a classic case from, I think, 2005 or 2006 that the Commonwealth Court held. That injury happening while they're engaged in their personal comfort, going to get a drink in their kitchen upstairs, that's a compensable workers' compensation claim, even if it happens at home. So here we have had many years of employers emphasizing safety in the workplace, safety in the workplace, safety in the workplace, and it has successfully cut into the amount of claims. But now employers might be getting the idea that it's cheaper or more effective to let people work at home, but they're not going to have any control over whether that's a safe environment at home. I mean, you know, Jason, I might have cable cords running all over my basement or my kids' toys, and I trip on a ball when I'm going to my computer in the basement. Or I don't have an ergonomic workstation at home like I do at the office. And I developed carpal tunnel. Those are all potentially compensable cases in Pennsylvania. To answer your specific question, it's a great question. Again, if we just back into the causation issue really quickly, if, you know, God forbid someone's spouse contracts a disease, let's say in a healthcare environment, and you then get the disease as well, many of the judges, I think, are going to say, well, his spouse had it or her spouse had it, and they were the ones who most likely transmitted it to the claimant. So it's a risk.
Yeah, it's a bit of a double-edged sword, I think, for employers. And Lee, your workplace looks very, very safe and clean there. It's very Spartan, and I think you'll be okay. But in all seriousness, I think it's a double-edged sword for employers in that you're not if it's a home-based employee, you don't have to worry as much about that employee exposing other coworkers. But as Lee said, you don't really have any control over the situation. And you certainly, I'm not a constitutional lawyer, but good luck mandating who the employee comes into contact with in their house. Hopefully we're all being, you know, clean. We're exercising cleanliness. We're washing our hands. We're not, you know, licking the handle from the refrigerator every time we get in it. But it's I think we'll see some of these claims. And frankly, I think this is probably as much of a wrap up as a preview, because one of the things we've been talking about doing going forward, probably for a video, is talking about work from home injuries, because I think beyond just these couple of months, I think more and more of our workforce already was moving into the home. And I think that's just going to accelerate now. So maybe that's what we'll talk about next time, Lee. Maybe we'll bring Brittany back and get a New Jersey, Pennsylvania viewpoint on it. But I wanted to thank you. Thank you for your time. Thank you for your information. Hopefully everybody out there has stuck with us. And if you are still with us, feel free to drop any kind of questions in the comments, send us any kind of emails. Lee, did you have any parting words of wisdom?
I just really want to help our clients make sure that they do the right thing by the claimant and by themselves. You know, we're here for you to help you answer questions or provide questions which will get to the bottom of your claim. I'm happy to help you.
Yeah, and Lee, I probably forgot to give the disclaimer that I should have given at the outset, but anything that we've said here in the last 15 minutes or so, it's not legal advice specific to your claims. It's a general conversation. But as Lee said, we're in Pennsylvania, but we're in Pennsylvania, New Jersey, New York. We're all over the East Coast. We're in a bunch of different states. So if you have any specific questions, feel free to reach out. I think all of our attorneys are very welcoming to the very famous hypothetical question that doesn't sound so hypothetical because it probably already happened. So go on our website, look up, I think we have a coronavirus section on our website now. So look up all that information, reach out to us. Frankly, I hope you don't have to. I hope you don't get any of these claims. I hope everybody stays safe and healthy. But for now, I think we'll wrap it up, and we'll probably be back with another video probably in the next week or so. So take care, everybody.
Thank you, Jason. Thanks, everyone.